Well, good morning, everybody. Welcome to the latest in the FTB webinar series. My name is Andrew Fraser-Urquhart QC. I'm joined this morning by Charles Forrest, who I think will turn his camera on in a moment. And just to say hello.
Good morning,
everyone. Good morning, Charles.
Morning.
And this morning we're talking about recent developments in enforcement, planning enforcement law and practice. It's the nature of an update like this, perhaps, that it's something of a potpourri of cases, and it wasn't always easy to see distinct themes emerging in a short span of time, but we'll try and draw together some threads of how enforcement practice is developing and changing. The format of this morning's talk is that after this introduction, I'm going to take us through two cases which do have an interesting bearing on how the COVID-19 pandemic may affect enforcement practice in the future. I'm then going to hand over to Charles, who's going to take us through three recent cases. Binning, which deals with the procedure on Section 289 appeals to the High Court. A Brent enforcement appeal case which deals with various points of enforcement appeal procedure, and the Melsels case which deals with the ever fascinating and endless saga of condition precedent. I'm then going to take over again to deal with a case involving judicial review of an informative on a fluid which I was involved with, QM developments. And then two very important heritage-based enforcement cases, the Dill Supreme Court case and a Tower Hamlets decision about demolition of buildings, both of which have considerable impact in the heritage enforcement field. And then we'll go back to Charles for two further cases, Pegnani on confiscation orders and Finnegan on Section 70C, another developing perennial old favourite. And following that, we'll take some questions from the Q&A prompt at the bottom of the screen, which I'm sure everyone's now getting very familiar with. Before I start, I should just perhaps formally introduce Charles Forrest. Charles Forrest is one of our most talented juniors. I'm afraid he still just qualifies as a junior, called to the bar in 2014, been a member of our chambers since the year after. Already has a very busy planning and regulatory practice. Have been heavily involved, for example, in the series of cases involving Aylesbury Vale District Council and challenges to their local plan. Been involved with the Hornsey offshore wind farm project. Been involved even in some of the Heathrow third runway litigation. Also has a fascinating backstory. Worked, for example, in, and this was a connection which I have to say rather escaped me, but worked in Minnesota on drafting laws for the Somali constitution. And obviously also with an interest in African affairs, spent time in Kampala in Uganda, teaching law to prisoners rehabilitating themselves. So a fascinating backstory and a very able and talented member of our chambers. So that's Charles, from whom we'll be hearing later. But for the moment, I think he will disappear now, and I will start in our seminar with looking at the first case. I hope you'll see my slides in just a moment. And there we are, I think. And we start with a case of Islington and the Secretary of State. Now, these first two cases that I'm going to deal with deal very interestingly with interruptions of periods which are being relied upon to accrue immunity from enforcement action. This has been something of a vexed area, and obviously the relevance that we see in these cases is that it is entirely possible that with the hiatus in economic activity caused by the COVID-19 pandemic, that these sorts of questions may arise afresh in enforcement actions in the near future. And so useful just to have a review of recent case law and not so recent case law perhaps on this topic. Now, interestingly enough, this issue arose obviously with some foresight of the future in 2019 in an Islington case. And the facts of it were relatively straightforward. There was a joint residential shop unit shop on the ground. I think it was an A2 use, and a basement which was ancillary to the shop, and residential units above. The owners carved out a basement flat. They changed the use of the basement without permission in April 2013 on a relatively basic way. It wasn't the most salubrious accommodation by all accounts, and that was done in April 2013. And as ever with enforcement, the dates are always of some relevance. Then in November 2013 to February 2014, the basement flat was then renovated. It was effectively completely gutted, taken right back to the walls and the building shell. And during that period, it was both uninhabitable and it wasn't something that you would recognize as being a residential unit, even if you chose to inspect it, obviously, until quite late in the renovation process when the cosmetic works were done and so forth. Anyway, the flat was renovated, and it was then reoccupied on a higher rent with a new tenant from February 2014 onwards. In due course, the local planning authority became aware of the development, and in January 2018, following a failed application for retrospective consent, an enforcement notice was issued. And those of you who are astute will notice from the dates that January 2014 was the cutoff. Now, given the rental in February-March 2014, the claimant needed the earlier period before the period of renovation. They needed that to be included within the 4-year period in order to make the necessary 4 years for immunity. The claimant argued that there had been no abandonment of the residential use, and that it was always the intention to resume residential use after the renovations. And that's pretty obviously the case on the facts. That there'd been a successful conversion to a residential use, as I say, albeit on a fairly basic level of comfort and so forth. And obviously considerable time and money had then been spent on making it a nice flat capable of renting out at a considerably higher rent. So that intention was patently always there. Now, the phrase that came to be used by the claimant and then in due course by the inspector was presumption of continuance, i.e. it was to be presumed, because of the intention, because there'd been no other use of the premises during the period of renovation, it was to be presumed that there was a continuance of the activity. And the inspector agreed and granted the certificate. Council took the matter to the High Court, and perhaps unsurprisingly, when one looks at the authorities, the court concluded that the inspector had erred in law. Now, there were a number of different grounds of challenge, but the one that succeeded was based upon the approach the inspector had taken to how that period of renovation should be taken into account, whether it could be taken into account in arriving at a calculation of 4 years use and therefore establishing immunity. And what the court said, that in fact this matter had been considered in some detail with some authority in 2 leading Court of Appeal cases, Thurrock and the Secretary of State, which was a 2002 case, and Swale, Secretary of State, in 2005. And what the law said clearly in those cases, and it was applied again in this Islington case, is that it had to be established that throughout the required period there was a continuous use during which time enforcement action could be taken. Now, just pause there. Clearly, as we know from other authorities, continuous use doesn't mean that literally every second of every day has to be in use for the particular use. People can go on holiday, people can on occasions have second homes, and yet the use continues as a residential use. But it has to be a use during which enforcement action could be taken, i.e. that there was some ongoing active use, even if it was temporarily paused, but it was an ongoing active use which was identifiable as such, so that an enforcement officer could come along, identify that there was use taking place, and begin enforcement proceedings. And what the court concluded was that it was obvious that enforcement action couldn't be taken during the period of renovations. During the period of renovations, there was no use going on, and all that was happening were effectively building works. And during that period, it wouldn't have been possible, because there was no use occurring at that point in time, for enforcement action to be taken. And so because of that break in the chain, the 4 years period wasn't established, and it was concluded that the inspector had erred in law. Now, there are two important points which arise out of this case, which may be of some relevance as we recover from the COVID pandemic. The first is this: one of the submissions that was made was that by the claimant counsel, who was seeking to overturn the decision. One of the points that was made was that during the period of renovations, it wasn't reasonably practical for enforcement action to be taken, because A, there was a difficulty of access, and B, there was a difficulty of seeing what was actually going on in the property. And thirdly, because there was no residential use taking place, because it was just building works, that it wasn't practical to take enforcement action at that stage. Now, what the court said, interestingly enough, was that it didn't have to be practical. There was no requirement that it be reasonably practical to take enforcement action. All that was required was that the planning situation, i.e. the use that was occurring, was actually a use against which enforcement action could have been taken in the theoretical planning sense, i.e. the planning situation was such that you could take enforcement action. It wasn't the practical difficulties of taking enforcement action which served to, as it were, stop the clock. It was the fact that there was no planning situation at that particular time against which enforcement action could have been taken. And it seems to me that this is quite potentially quite important for a period of time when obviously access to property is very constrained by requirements of social distancing and so forth. One might imagine that there are considerable practical difficulties for local planning authorities in seeking to undertake enforcement action. But the court said pretty clearly in Islington that sort of practical difficulty does not prevent time running. It's only if the planning situation on the land prevents enforcement action being taken that there is a stopping of the clock. And so although the case isn't framed around particularly the issues of the practicalities of access and the things which might be relevant in the COVID situation, it's nevertheless the case that the authority does say pretty clearly that it's not a matter of an absence of practicality that stops the clock. And I think this case has some clear overtones for what might be coming around the corner in terms of enforcement. The other point, which is more a point of legal interest than a point of the reasoning of the case, is that the approach which the original developers had urged upon the inspector, the original appellants had urged upon the inspector, which the inspector had mistakenly taken up, this point about presumption of continuance, that did have a basis in authority, but the authorities were directed at the wrong target. What the cases make very clear is that there is a fundamental difference between the law relating to the abandonment of an already existing use on the one hand, and the halting of an unauthorized use in terms of whether or not the clock keeps running towards enforcement immunity. So once you've got an established use, lawful use, it's very hard, as we know, to demonstrate that it has been abandoned. Usually it takes a new planning permission or the commencement of a use which is materially different and is entirely inconsistent with the existing lawful use before there can be abandonment. The mere cessation of activity is rarely enough to bring about the abandonment of an existing use. So once you get to the stage of having a lawful use, it's very difficult to abandon it, and it's in that context that you get case law and phrases such as presumption of continuance and so forth. And the error that the inspector was seduced into by the obviously very able advocates for the original developer was that he used that body of law in a situation which it wasn't designed for. What we are dealing with here, of course, is how do you demonstrate continuous use for the purposes of keeping the clock ticking towards enforcement immunity? And that's an entirely different kettle of fish, because you don't have a lawful use. You don't, in effect, get the benefit of the difficulty of abandoning it. And therefore, you, in those circumstances, you do have to show this continuous use, not day by day, minute by minute, as I said, but in any situation where the planning situation on the land has to continue to be always the continuation of the unauthorized use. So that's the legal basis for the distinction, and we see from Islington this important point about the practicality of taking enforcement action. The next case, and this is really to illustrate the point rather than it being a recent case, because as you see, it comes from 13 years ago, Miles, the National Assembly for Wales. And this is a very interesting case because it does, for our purposes, it does touch upon a sort of natural disaster interrupting activities. Facts were these. A farm owner sought a lawful development certificate for the use of land for various motorcycle racing and practice activities. Effectively, it was a dirt track motorbike racing, and some family members and friends also used the land for practice for the occasional races. And it was suggested that there was therefore a long-standing breach of the 28-day temporary uses limit, and therefore that a new use had been established. Now, the bulk of the argument in the case was actually around an issue which doesn't really concern us, about whether race days and practice days could be aggregated, and that's one of the main bases upon which the case was decided. But, and this is where it becomes interesting for present purposes, the period during which immunity was said to have been acquired included the period of the big 2001 foot and mouth disease outbreak. You'll perhaps remember that there was that foot and mouth outbreak. I seem to recall it caused the general election to be put back from the desired date by a month because ministers didn't want to go to the polls during a foot and mouth outbreak. Anyway, this caused quite a long hiatus in activities in rural Britain, and there was an 18-month period when there was no activity. None of the motorcycle activities took place because of the foot and mouth restrictions. And the inspector concluded that that broke the period to establish the 10-year immunity. The claimant said that that period should not be included, that period should be included, i.e. that the period when there was no activity nevertheless counted towards the 10-year period. And the court argued that it was possible to take enforcement action. Now, it wasn't a consideration of the practicalities, that was what Islington dealt with. But the court simply looked at the planning situation. The claimant said, forgive me, the claimant said that it was possible to take enforcement action. There was nothing stopping the local planning authority seeing what had been going on the land, assuming that that activity had continued, and then taking enforcement action. But the court said, and they applied the Thurrock case, and then said that when the planning situation was such that there wasn't any activity going on, because the activities had been suspended, that the enforcement action couldn't in those circumstances be taken back to the principles applied in Thurrock, which we've seen looked at in Islington, because the planning situation prevented enforcement action being taken. The clock stopped running at that point, and so the claimant failed. And the important point to draw from this case is the court was very explicit that the fact that the suspension was due to circumstances beyond the control of the applicant, beyond the control of the landowner in this case, and the fact that they had an intention to resume, that intention to resume as soon as they could was apparent to all, that wasn't relevant. Now, it's a pretty tough call for the developers in some way, but there have been a lot of tough calls for a lot of people in this COVID pandemic, and this in terms of planning enforcement is another one. The mere fact that a suspension of the activity has nothing to do with you and is due to circumstances entirely beyond your control doesn't mean that the clock keeps running. The clock stops as soon as the activity in planning terms comes to an end, and it's then regarded as having restarted whenever the circumstances beyond your control come to an end and you can resume. And the fact that you wanted to resume all along, it would never have stopped, apart from foot and mouth, or in cases we're likely to see because of COVID, is irrelevant. The only question, the court said, was whether or not it was possible in the planning sense to take enforcement action. So that's, I hope, some useful introductions to case law, which may well be relied upon quite a bit in some of the arguments which are coming because of COVID. Well, that's my first introductory couple of cases. I'll now hand over to Charles, who will take us through the next three in this little tour around some recent interesting enforcement cases. Charles.
Thanks, Andrew. Morning, everyone. I'm just going to try and share my screen, which it looks like I've been able to do. Lovely, great. I think that's worked. Right. So I'm going to speak about three cases before passing back to Andrew. The first of which is the case of Binning Property Corporation and Secretary of State for Housing, Communities and Local Government. It's a decision of Lord Justice Lindblom, and I've just briefly set out the facts there on the slide, which I'll go through. An enforcement notice was issued by the council alleging the unauthorised storage of aggregate and containers. The appellant appealed under section 174, but the inspector dismissed that appeal. The appellant then appealed under section 289 to the High Court against the dismissal of that appeal. And as many of you will know, in order to appeal under section 289, that requires leave. You need permission in order to bring that appeal. Well, the High Court refused leave to appeal in this case, and the appellant then applied for permission to appeal that decision to the Court of Appeal. And the Court of Appeal held an oral hearing, and the issue in that hearing was, does the Court of Appeal have jurisdiction to hear an appeal against a decision of the High Court under section 289(6), refusing leave to appeal against the dismissal by an inspector of an enforcement appeal? Now, obviously, in judicial review, the Court of Appeal does have that jurisdiction. If you bring a judicial review and permission is refused, you can appeal that to the Court of Appeal. Likewise, in section 288 challenges, which relate to various planning orders and decisions, you can also appeal that to the Court of Appeal. The question is, can you do that in section 289? Well, this isn't a new issue. The Court of Appeal has previously said, no, you can't in the context of section 289 appeals, and I've set out some of the case law there. It's a long line of authorities from the Court of Appeal saying, no, we don't have jurisdiction against a High Court decision refusing leave in a section 289 appeal. So this wasn't a new issue. So why was the appellant bringing the claim, and why was the Court of Appeal agreeing to hear it? Well, it's because in this case, the appellant was making a series of rather ingenious arguments, essentially trying to say that the situation has since changed. And I've just set out a couple of their arguments there. They argued that, well, because of the reforms to the procedure for cost capping in Aarhus Convention claims, many of you will be aware of the Aarhus Convention and the effect it's had on procedure in English planning and environmental law, essentially giving cost capping for parties particularly beneficial to claimants, cost capping against adverse cost orders in order to facilitate the bringing of claims and the protection of the environment. Now, this has been the case in English law for a long time, about 7 years now, but there were some more recent amendments in 2017. And what those amendments did was what the appellant said is that it's clear that all claims should be treated alike. Judicial reviews and reviews under statute, which includes Section 289 appeals, as well as Section 288 challenges. Now, obviously, those of you who are familiar with those provisions knows that there actually is a fair amount of difference actually in how those claims are treated in practice, the extent to which those claims fall into the cost protection regime. But in principle, the appellant was saying that these changes shows that it's clear that these claims should be treated alike. The second argument that was being relied on by the appellant was that there's also been amendments to the Town and Country Planning Act 1990. About 5 years ago, many of you remember, there was introduced in Section 288 challenges a leave filter. Previously, you didn't need leave to bring a Section 288 challenge. As of 2015, 2016, you did. And therefore, these previous Court of Appeal decisions, which relied on the disparity between Section 288 and Section 289 claims, that was no longer justified, because in both types of claim, you need leave to appeal. So, was that correct? Were the appellant's arguments valid? No, the Court of Appeal dismissed the appeal and held that it does not have jurisdiction to hear an appeal against a High Court decision on leave under Section 289. And the Court of Appeal had a number of justifications for that. The first was just a simple matter of precedent. It was felt itself bound by previous authority, those cases that I referred to a few slides ago. And many of you will remember perhaps from your law school days that the case of Young and Bristol Aeroplane, which sets out the very few circumstances in which the Court of Appeal can go against one of its previous decisions, and none of those conditions or requirements were met in this case. So it was a matter of precedent first and foremost. But what the court also did is it actually looked at what underpinned the reasoning of those previous cases, and it said, well, actually, the reasoning still prevails just as much as it always did, notwithstanding the changes in the law that the appellant had identified over the last 6 or 7 years. So the reasoning which the Court of Appeal still said prevailed was that there's a basic principle in a case of Lane and Esdale which says the general proposition that whenever a power is given to a court or tribunal by legislation to grant or refuse leave to appeal, the decision of that authority is, from the very nature of the thing, final and conclusive. That is subject to a residual jurisdictional discretion, which didn't apply on the facts here, and indeed is unlikely to apply in the vast majority of the cases, which is that the Court of Appeal re-emphasised that it does have the power to overturn a High Court decision to refuse leave to appeal if the process by which the High Court made that decision has demonstrably been vitiated by misconduct or unfairness. And obviously that's likely not to be the case in the vast majority of cases. The Court of Appeal also said that the High Court's judge's refusal of leave to bring a Section 289 appeal was not caught by Section 16 of the Senior Courts Act. In other words, it's not a judgment or order of the High Court in relation to which the Court of Appeal has jurisdiction to hear and determine appeals. And the Court of Appeal also pointed out that there's been no change to Section 289 in the meantime. Obviously, there's been changes to the rules on cost capping, there's been changes to Section 288, but there hasn't actually been any changes to Section 289 itself. And this is further justification for the Court of Appeal's decision. Section 54, subsection 4 of the Access to Justice Act says that no appeal may be made against a decision of a court under this section to give or refuse permission because no rules of court have provided otherwise. And obviously for judicial reviews in Section 288 challenges, rules of court do provide otherwise. And you can find that in the CPR, Part 52 and Part 8. So the CPR does provide otherwise in respect of those claims, but it still doesn't in relation to Section 289 claims. And finally, there's the policy reason which the Court of Appeal emphasised, and those policy reasons still prevail, which is that what the requirement for leave in Section 289 appeals is aimed at is to discourage unmeritorious appeals, especially where they're made for the purpose of suspending the effect of the enforcement notice pending the final determination or withdrawal of the appeal. And although there is provision for the court to say the enforcement notice will have effect, the presumption is that appealing against the enforcement notice suspends its effect. And what the Court of Appeal didn't want to do was to say, well, appellants can just keep on appealing up to the Court of Appeal when they haven't really got a case, and purely to suspend the effect of the enforcement notice and for the breach of planning control to carry on going. So I suppose the lesson in this case is that this issue, and the court was quite clear, this issue really has been put to bed. Lord Justice Lindblom said that if this situation is going to change, it really will have to be an amendment to either Section 289 or an amendment to the civil procedure rules in the way that's happened for JRs in Section 288. So you'd be well advised to resist any attempts by clients to try and push this one further, or at least manage their expectations heavily that it's highly unlikely to be successful unless the case falls into that small category of claims where the High Court's decision refusing leave to appeal has been vitiated by misconduct or something along those lines. So that was Binning. Now on to the London Borough of Brent and Secretary of State for Housing, Communities and Local Government. It's a 2019 case of Neil Cameron QC sitting as a Deputy High Court Judge. This case relates to fairness and considerations to be taken into account by inspectors in Section 174 enforcement appeals. So just a quick summary of the facts, because they are more important in this particular case. In 2017, April 2017, the council issued an enforcement notice in respect of land controlled by a school. And what that enforcement notice said, having been amended by the inspector at the inquiry, the enforcement notice alleged, without planning permission, the material change of use to a mixed use as a school and parking, i.e. parking which is not ancillary to school use, but which is also a primary use along with the school, hence the allegation of mixed use. The school appealed against that enforcement notice, and they appealed on ground D. And what they asserted was that the use was lawful as it had taken place in excess of 10 years prior to the date of the enforcement notice, obviously 10 years being the relevant period for material change of use. The inspector allowed that appeal because she found on the evidence that the mixed use commenced on the 24th of March 2007, and it continued for a period of 10 years prior to the enforcement notice being served. The enforcement notice was served in April 2017, so they made out the 10 years, they satisfied the inspector of that. The council appealed under section 289 on this ground. They argued that the inspector had failed to grapple with its case that was put in the alternative, that a second material change of use of the land, so they were saying there was an initial material change of use which first started on the 24th of March 2017, but they also argued in the alternative, well, in any case, what happened in 2016 was that there was an intensification of that use, and as many of you will know, an intensification of an existing use can be a material change of use, and the case of Hertfordshire is authority for that, and there have been many since then. And the way the council put that alternative case was in its closing submissions. It mentioned a change in the character of the use, and it referred to that case of Hertfordshire, which I just mentioned, and indeed it placed it before the inspector. So they were arguing that we argued this alternative point in our closing, and it was agreed that there was no indication in the inspector's decisions letter that she considered this matter. The issue was whether she was obliged to consider it and deal with it in her decision letter. And what the court ruled was, well, as a matter of statutory construction, there's no obligation on an inspector to cast around to ascertain whether some further or different breach of planning control to that alleged in the enforcement notice had occurred. And in this case, that intensification argument in the alternative was not in there. And the justification for this are numerous. Matter of natural justice, that parties should bring the case that they are putting, and that other parties should know what that is and be able to respond to it. It's not about the inspector to, as it were, go on a frolic of his own and sort of silently try and cast around for different arguments or different cases. And it's also a matter of practicality, that actually it would be too burdensome for an inspector to have to essentially facilitate various arguments or the cases of various parties. So as a matter of construction, there was no obligation on the inspector to do that. And also as a matter of statutory construction, specifically in relation to intensification, an inspector is not in every case required to consider whether the use subsisting 10 years before the enforcement notice was issued has, within that 10-year period, changed to such an extent as to be an intensification constituting a material change of use. So again, the inspector does not have to do the legwork on intensification for any party, doesn't have to expressly cast around for it. It's up to the parties to bring it. And indeed, the appeal was allowed on that basis, because in this case, the council's closing submissions, as I said, did contain a clear indication that a material change of use arising by way of intensification was being relied upon in the alternative. And what the court said was, well, although it would have been desirable for that alternative argument to have been raised earlier, either in the enforcement notice or as an alternative matter appearing earlier in the inquiry or during the evidence, that was not essential. That can be raised in the in closing submissions, and anyone involved in enforcement appeals will know that it's quite common for new points, legal points or something based on the evidence to be raised at that stage, because sometimes it's contingent on how the evidence has turned out. So although it would have been desirable for the council to raise this earlier, the point is they did raise it in their closing, and it was plainly relevant to the issue, which the inspector had to determine pursuant to ground D, and it was capable of defeating that ground D claim, and so therefore it should have been taken into account, but there was no evidence in the inspector's decision letter that she had taken it into account. The court also said in relation to the Findlay principles, what the appellant was arguing was that basically the inspector should have taken this argument into account under the Findlay principles, which provides that where a statute confers a discretion on a decision maker, then some considerations will be so obviously material that anything less than consideration of them would be an error of law. Now, the court said that it wasn't convinced that those principles applied in these circumstances. However, if they did, then this type of argument raised at this stage, notwithstanding the fact that it was late, this or later on in the process, this kind of argument is the kind of consideration which would be so obviously material to that ground D issue which the inspector had to determine. It would have been one of those ones which was so obviously material that it would have been an error of law not to take it into account. So the third case before I pass back to Andrew is a case from last year. It's Melsels and Secretary of State for Housing, Communities and Local Government, decision of CMG Ockelton, and it relates to conditions precedent. And there is, in a long line of authorities, what's sometimes called the Whitley principles, which is there is a distinction between conditions, a distinction between pre-commencement conditions and conditions precedent. The only problem is it can sometimes be quite difficult to know what that distinction is. So a pre-commencement condition is a condition which merely requires that something must be done before development commences. A condition precedent is a condition which goes further and requires that development cannot commence unless it is complied with. And why does this matter? Well, it can be very significant, because if a condition precedent is not complied with, then the development is commenced unlawfully without planning permission, and all of the development undertaken under the permission is unlawful and can be enforced against. So it's not just about, well, you breached this condition and we will serve an enforcement notice on you or a BCN on you for that breach of condition. If it's a condition precedent, the point is that all of the development is unlawful, and in this particular case, the development had progressed to a great extent. So if the local planning authority is enforcing against all of that development, well, obviously that is a big problem. So that's one reason why it matters. It also matters because it affects whether development is begun in time. Obviously, every planning permission has a condition attached which says development must be commenced within X period of time. Well, if you breach a condition precedent when you commence works, that will not count for the purposes of initiating development. That can't be taken into account in deciding that question, and indeed that's what happened in this particular case. So how do you determine what's a pre-commencement condition and what's a condition precedent? Well, there have been many cases that have been that have dealt with this. Is it just a matter of the wording of the condition? Or do you also take into account the subject matter of the condition? Do you look at things more holistically, and you look at, well, what does the condition relate to? How important is that in the context of the permission? For example, maybe a condition which relates to access on a big housing development, arguably you could say, well, that's actually very important, and that does go to the heart of the planning permission, and so is a condition precedent. But as I said, it can be sometimes difficult to know how to distinguish between the two. So I'll very briefly go through the facts of Melsels. It's that the condition required submission to the council of materials to be used in constructing an extension to a synagogue. That condition was not complied with, and the enforcement notice was issued against all the development under construction. In other words, the council was saying that this was a condition precedent. And the inspector on appeal agreed. He said that this condition, which had not been complied with, went to the heart of the planning permission because it fundamentally controlled the final appearance of the building and its relationships to its surroundings. So the appellant appealed to the High Court under section 289 against the inspector's dismissal of their appeal. And this is what the court said about this issue of how do you determine between the different types of condition. It said whether a condition went to the heart of the planning permission could only be answered by a fact-sensitive inquiry into the terms of the condition in the context of the planning permission. In other words, it's not just about the wording of the condition. It's not just about councils identifying on planning permissions, as they sometimes do, that, well, listen, these are the conditions that we believe are the conditions precedent. It's about that fact-sensitive inquiry into the terms of the condition in the context of the planning permission. This is a question of planning judgment, not for the court, and accordingly, as one would expect, unless the decision maker's decision on the issue was at fault in a Wednesbury sense or public law sense, the court would not intervene. And indeed, in this case, the court did not intervene or impugn the inspector's judgment that this was a condition precedent and that the enforcement notice would therefore be upheld. Just a final point before I pass back to Andrew. In England, now in regulations from 2018, this applies only in England, the Town and Country Planning Pre-Commencement Conditions Regulations 2018, it's now a requirement for an applicant to agree to pre-commencement conditions before they can be imposed. Often, people are so happy they've got their permission that they don't really look at the nuts and bolts of the conditions. This provides a mechanism where they have to agree before they can be imposed. So that's just a little postscript. Right, well, that's all from me for now, and I'll pass back to you, Andrew.
Thank you, Charles. Very interesting and informative. I'll now go back to sharing my screen. And we come now, continuing to an extent with this theme about pre-commencement conditions, to the somewhat extraordinary case I was involved with earlier this year of QM Developments. It's very much actually a case of two halves, if you'll forgive the football analogy. The first half is a reasonably straightforward matter, and that's the part from which there's a takeaway from this case about the ability to judicially review informatives on certificates of lawful development, and a very much more murky second half about pre-commencement conditions and enforceability. The facts are rather extraordinary. In 2008, there was planning permission granted for 2 houses, and because it was in an area where there'd been previously various brickworking activities, a pre-commencement condition requiring a gas remediation investigation and, if necessary, treatment was applied to the permission. The developers asked the council whether they might begin development without all of the elements of the pre-commencement condition having been complied with, and the council verbally and then in an email agreed to let them do so. Then an amended planning permission was granted, dealing with various amendments to the scheme, but somewhat extraordinarily, exactly the same conditions, i.e. the conditions before the verbal allowance to start, however one characterizes it. I mean, on the slide I've called it the variation of the condition, but if it was a variation, it would probably have been an unlawful variation because it was done without any proper procedure, and see the Henry Boot case, which says that such an informal variation isn't permitted. Anyway, be that as it may, an amended planning permission was imposed and the development continued. Now, the local planning authority weren't satisfied with the subsequent discharge of the gas remediation condition. And then the case took an unusual turn in that the original developer of the land and the purchaser of one of the houses clearly fell out, and litigation began between them. We think, and I use that phrase advisedly, we think it was because the house owner felt he'd been in some way deceived or let down about the fact that the council was still regarding one of the so-called pre-commencement conditions, the council was still not satisfied that it had been discharged. But I say we think advisedly because we never, in the course of this litigation, actually discovered, in the course of the judicial review litigation, actually discovered what the satellite litigation between the developer and the house owner was actually about. And indeed, my poor opponent, who was asked about it, acting for the developers, was asked by the judge what was the litigation about, and even she didn't know. So it was a very strange scenario. Anyway, as part of the manoeuvring involved in this satellite county court litigation, about which we knew very little, the developer applied for a lawful development certificate. And the council looked at the development, concluded it had been carried out in accordance with the plans, albeit with some differences, but not enough to make a material difference, and concluded that what they had done by way of allowing the commencement of the development before the pre-commencement condition had been complied with, that variation, however it was described, concluded that that meant that the development had been lawfully commenced, was lawful, and so the certificate was granted, but an informative was added saying that information was still required concerning the gas remediation condition, effectively saying it hadn't been fully discharged. Now, this obviously didn't suit the developers, so I think their whole rationale for seeking the certificate was to try and help in their litigation against one of the house owners. And somewhat extraordinarily, they began judicial review proceedings of the council's decision to impose an informative. Perhaps impose is the wrong word, to add an informative, because clearly an informative is of no legal effect. Now, it was common ground between the parties that the informative was of no legal effect. And the first half of the council's case was to say, well, this just isn't something which is justiciable in a judicial review proceeding. How can a gratuitously added, gratuitous in the strict sense of the term, informative, which is added by a council, which is meant simply, clues in the title, to be information given to a developer about the position and given to all the world about the position, how could that be the subject of judicial review proceedings when it was of no legal effect? Now, the claimant claimed that they wanted to establish the position for the county court litigation and attempted to suggest that the High Court was better positioned to delve into all the issues of the legality of the condition and so forth than a county court would be. Now, whatever the merits of that view at a practical level, and perhaps there are some, it clearly was never going to be something that the court was ever going to accept. The High Court would ever accept that its role as effectively a court of last resort, if there was no other way of resolving dispute, that it could be used as a sort of convenience because it was thought that a county court judge wouldn't be able to properly wrestle with what is, to be fair, a fairly complicated issue. That was never ever going to fly. Now, those of you listening who are familiar with JR may be wondering, well, how on earth did this case ever get permission? And that was also, frankly, a question which I had in my mind, because it seemed to me that this was not a case that should ever have got permission. I think what probably happened is that it was put before a non-specialist planning judge because the claimants ran the case in the ordinary Queen's Bench division and didn't put it in the planning court. So it came in front of a non-specialist judge who I'm afraid to say I think sort of saw it looked rather complicated and decided therefore that it probably was arguable and gave permission. In any event, when it came before Mr. Justice Dove, it was held very clearly that this was an inappropriate case to bring as a judicial review claim because the informative was of no legal effect, and the High Court and the judicial review jurisdiction wasn't a matter of convenience to enable people involved in litigation to have another way of settling a legal dispute for the purposes of that litigation. And so the court held very clearly that an informative was of no legal effect, it wasn't appropriate for judicial review, and that there were a series of adequate alternative remedies. The one that the court held to be definitive of or determinative of this particular case was that the position could just as well be established in the county court. The county court perfectly capable, obviously, of hearing an argument, even non-complicated legal planning issues, and coming to a determination on what the legal position was. It didn't need a challenge to a non-legally binding informative gratuitously imposed by a council to establish that. It was also argued, and I think correctly argued, that the only remedy or the only thing a council could do in the event that it was not satisfied that a condition had been complied with was either to bring breach of condition proceedings, in which case the claimant, as part of its defence, would have been perfectly entitled to argue under the usual principles that the condition was not valid, or to have rung an enforcement notice, in which case, of course, there's an enforcement notice appeal where the whole matter could have been ventilated in front of a specialist planning inspector. Or indeed, the final possible alternative remedy would have been to have appealed the certificate and argued that the certificate in the form in which it was granted should not have been so granted. So a frankly thoroughly misconceived piece of litigation by the claimant, and to complete the football analogy, perhaps it was the scoring of a relatively open goal to knock it back, but the case is nevertheless useful for definitively establishing that it is almost impossible to judicially review an informative on a fluid. So from perhaps the sublime to the ridiculous, we come to the perhaps rather more consequential Supreme Court case in the matter of Dill. Now, this is a matter which plenty of discussion has already occurred, so we'll trot through it. You've got quite extensive slides, and far be it from me to confess that they were taken from a seminar I've previously done in rather more detail on Dill, so we shall trot through them at some speed. Two 18th century lead urns were resting by gravity on a limestone plinth at a place called Idlicott House, having started life at Rest Park in Bedfordshire in 1725, undoubtedly of artistic value. They ended up at Idlicott House, which is that idyllic looking setting. They form part of the decoration of the grand driveway, but they were sold at auction in 2009 and in fact removed overseas. The house itself had been listed in 1966. The urns, which were called throughout the case the items, in order to use a totally prejudicial term. The items were added to the list in 1986. There was no record, the listing decision couldn't be found, the notice of the listing hadn't apparently been sent to the owner. In another little twist in the facts, when the owner sold the items, put them up for auction, he actually sent notice of sale in advance to English Heritage, not for any reasons thinking that they had some obligation to be informed because they were listed, but simply because they were items of artistic interest which the vendor thought English Heritage might be interested in bidding for. So by that route, at least, English Heritage were notified, but they didn't buy them. They were sold and went overseas. They were limestone pedestals of a slab nature, which formed piers. The piers then rested on concrete slabs, which simply rested on the ground, and the urns sat atop the pedestal. So there was no attachment at any stage. And when they were removed, I've made an interesting typo here. At the top of the piers, and that should be P-I-E-R-S, because we're not involved in a wholesale removal of the House of Lords at this point. When they were removed, the top of the piers, P-I-E-R-S, they were lifted together, and then the remaining part of each pier was taken out, and the whole thing sat on the back of a low loader. The point being that they were not affixed, not attached to even to one another, let alone to the ground. In 2015, the local planning authority, having finally become alerted by whatever means, having noticed, however one puts it, that these items had gone, wrote to Mr. Dill asking him to secure listed building consent. He applied for it, it was refused, and an enforcement notice was issued. And this is where it gets interesting. At the appeal, the inspector concluded that the status of the items as buildings had been settled by the fact of listing and couldn't be considered again. So once they were listed, the issue of whether or not they in truth consisted of a building, which is we'll see the central criteria for having something as a listed building, that it be a building, or one of the central criteria, that couldn't be reopened. And that was a view that was accepted by both the High Court and the Court of Appeal. They both accepted that the listing decision had settled the issue of whether they were a building and it couldn't be reopened, and off it went to the Supreme Court. Now, the Supreme Court identified that there were two issues, but in fact it decided three issues. The first was the issue of whether or not the inspector could consider the issue of whether or not the items were a building. And if he could, secondly, what were the correct criteria to apply? But it also considered, it didn't say it was doing so, but it expressed extensive views on it, the so-called extended definition of listed buildings, the curtilage listed buildings definition, which is contained in section 1.5 of the Act, whereby a listed building includes a building in the list, obvious, and secondly, an object or structure fixed to the building or within the curtilage which forms part of the land. So curtilage listed buildings are as the shorthand term is used, is fixed structure fixed to the building or within the curtilage which forms part of the land, and has done so since before planning began, July 1948. And of course, the central part of consideration of a building is that a building is a structure or erection, and any part of a building, with the exception stated there, which we're all pretty familiar. So the process then is as follows. We're all familiar with the process for consent applications and appeals. What you can claim, what you can deal with in a consent appeal, and this was common ground and it flows directly from the legislation, is a claim that the building is not of special interest, i.e. you can say it's not of special interest, but you are still compelled, or so the lower courts had found, to accept that it was a building, and so you were arguing about special interest rather than about the basic criteria as to whether or not something was a building. And again, that ability to argue that point is carried through into listed building enforcement notices, and the Secretary of State has the power to remove a building from the list. Of course, none of this touches on the point that you can't argue about whether or not something is a building. So said, or so it appeared to say the legislation, and so said the lower courts. Well, the House of Lords, forgive me, the Supreme Court, shows my age, the Supreme Court didn't have much truck with that approach. Lord Carnwath dealt with it, as he said, relatively shortly, which is judicial speak for bleeding obvious, usually. And the view was simply taken that it was a fundamental right, and the case that was relied upon as setting it out was the Boddington litigation, 1999, in the then House of Lords. It was based on an individual's fair opportunity to challenge legal measures, to challenge legal measures which affected them. Now, the Secretary of State argued that the ability to judicially review the original listing decision was sufficient protection, i.e., when the building is listed, you have the right to judicially review it. In theory, if you only discover about it much later, you might have a chance, might I say, because it's by no means certain, you might have a chance to apply to extend time for your judicial review, even if you're coming to it some time later. The Secretary of State said that was enough protection, and the case that was relied upon was another High Court, House of Lords case, EWHC, which held with respect to the planning enforcement notice scheme that you had to just look at the statutory scheme and see what grounds of appeal there were, and anything else was left effectively to the residual, as we talked about in QM developments, the last resort jurisdiction of the High Court. Well, Carnwath said, well, that was wrong, and in a sense, the use of the EWCA case really gave him his point, because EWCA was based on planning enforcement notices, and it was explicitly said that the statutory grounds of appeal are so wide in planning cases, are so wide that they include really every aspect of the merits of the decision to serve the enforcement notice. Now, contrast that with the relatively narrow statutory grounds upon which listed building appeals can be made, and in particular the absence of that ability to challenge the fundamental, one of the two fundamental characteristics of a listed building, i.e. that it be a building. And so what the court said, they rather flipped it round, is that in the absence of a explicit statutory exclusion saying you can't argue this, which as we know does exist in some legislation with respect to possible grounds of appeal, in the absence of that explicit exclusion, there was no reason not to be able to argue that it wasn't a building. And so the appeal on that issue was allowed, and that much wider jurisdiction based on this principle of having a fair opportunity to challenge legal measures was what carries the day. And that's where the case may well have some interesting wider implications, not just in listed building enforcement, but in other forms of statutory appeals which have a statutory underpinning and a statutory set of grounds of appeal. Query now whether or not one is going to be able to argue on a much wider principle that other issues should be allowed to be raised. Now, the extended definition, which I'll skip over fairly briefly, this is the curtilage listed buildings in effect. There was a note about this particular issue of there are in fact a remarkably large number of structures in parks and gardens which are of themselves regarded as being listed. And there was a distinction between whether something is a building in its own right or whether it's simply treated as being part of the wider curtilage, either by being fixed to the building or being part of the land which is in the curtilage. And Carnwath noted that this had been rather blurred in official publications, and where he found his assistance was in the law of real property, land law. and that this was in the issue concerning the authorities on fixture to the land. And generally speaking, if something wasn't fixed to the land, which of course these structures weren't, then they wouldn't be regarded as being part of the land. The only circumstances in which they might be is if they'd been some essential part of the overall design of a house and garden. So, for example, I don't know, a very prominent sundial, which was the focal point for all of the hedgerow alignment in the garden, might be regarded as being an essential part of the design of the house and grounds. By definition, in this case, because the items had been brought onto the land long after the house had been built, it couldn't fall into that category. And so the test relied on, for the extended definition, method and degree of annexation, object and purpose of the annexation. And the court found on that basis it wasn't within the extended definition. So then Carnmouth came back to the second issue that the Supreme Court had identified: what's the proper test for a building? And this really represents, the judgment represents the reading into listed building law of the pre-existing line of authority, which culminated for planning purposes in the Skerritt's decision, which was also the first Court of Appeal consideration. Cardiff was a rating case. Barvis, which was a case involving a mobile crane, which ran on a little railway track for a couple hundred yards to enable it to be in the best position to pick up large items. That was held to be a building. And Skerritt's, which was you probably remember, was the marquee, which was erected at the beginning of the season in those happy days when we could have parties in marquees in the summer without having to be 2 meters away from each other. But in those happy days, a marquee was erected. It was fairly firmly fixed to the ground, albeit not permanent. It took a couple of days to put up at the beginning and a couple of days to take down at the end of summer. And that was held to be a building. And Carnmouth said that was the right test. The Skerritt's test was the right test to determine whether an object was a building. So therefore, the threefold test: size, and one of the particular points of reference for the size of a building is whether it would ordinarily be brought to the site assembled, or whether you had to bring it on in component parts and assemble it there. The permanence, 5 months of the summer season was enough for it to be a building, and the degree of physical attachment. And again, spikes into the ground were enough for the marquee. The limestone plinths resting on the ground for these 18th century urns were not, or were unlikely to be so. Some degree of movement was permitted. The mobile crane in Barvis I've spoken of. Interestingly enough, and this in some ways sets up rather a tension in the litigation and in the testing, in the Barvis case, there was a pretty clear acknowledgement that policy objectives, i.e. that if a thing was frankly big enough that it could have an effect on amenity and other impacts, then one should try and see that local planning authorities have some control over that. And so a policy objective of allowing a local planning authority some control would tend to push decisions in favour of things being buildings and therefore subject to control, rather than not buildings and therefore outside the scope of planning control. Poor old Mr. Dill in this case, unfortunately, the matter was remitted for rehearing, and the courts were clearly sympathetic that poor old Mr. Dill, after 20 years or 10 years after he'd sold the wretched urns, and as he no doubt sees them now, and 5 or 6 years after the litigation began, that he still can't get a decision on the fundamental issue of whether these things are buildings. Nevertheless, the Supreme Court said it was a matter of fact and degree and had to go back for rehearing. There were some factors in each direction, although one got the very strong sense that the Supreme Court thought that it wasn't a building, but they didn't determine that. There was also a very strong suggestion, seen as the fact that the items were long gone, and that the house was still there and rather grand and magnificent and so forth, that it really wasn't expedient for the local planning authority to continue to pursue this matter. Whether they will take the hint, we shall see. But anyway, that is the Dill case. So important really for twofold. The first is this possible way in which the grounds of appeal, not just for listed buildings, but with respect to other statutorily founded appeals, there might be a way of expanding the matters that can be considered. and then the writing into listed building law of the Skerritts three-stage test. And then just finally from me, the Tower Hamlets case from last year. This is a case where there was some fairly undistinguished buildings in the Tower Hamlets conservation area, and they were unlawfully demolished by persons unknown, which suggests an interesting set of background facts, but they were unlawfully demolished and rebuilding orders were made against the landowner. And the appeals against those were allowed, and the inspector effectively reasoned that the demolition had done more good than harm because it would lead to a suitable redevelopment of the site. Now, characterized in legal terms, that dispute was whether or not the public benefits of the proposal should extend to the likely benefits of new development of the site, which of course is dependent upon demolition of the existing buildings, in circumstances where there wasn't currently even an application for planning permission for the redevelopment, and therefore clearly no certainty that any redevelopment would come about. Or whether, when looking at that overall public benefits test, you were simply considering the public benefits of demolition. Of course, if they are a complete eyesore, particularly if they're unlisted buildings within a conservation area, there may be some benefit just from the demolition itself. The key question is whether or not you could consider effectively an uncertain potential for redevelopment. Perhaps rather surprisingly, the inspector said that you could. He accepted that the benefits were speculative, fair enough, but concluded that it was highly likely that a suitable proposal could be found. And the court agreed. The court said that the inspector had been entitled to take into account the likely future benefits. Now, I have to say that's quite an important and perhaps rather surprising outcome in a situation clearly where there's a defined scheme and one can assess those benefits. Well, then that seems perfectly logical to take them into account. But where the inspector himself is concluding that the benefits are speculative and relying only on a likelihood, even a high likelihood, of finding a suitable proposal, does seem to me to be slightly surprising that those benefits could be taken into account. Nevertheless, that's where the law now stands, and we will see whether this becomes one of those decisions which sits there as an outlier and is conveniently worked around. Clearly, there are some factual parts of the decision, the fact that it was unlisted buildings in, I think, a fairly run-down part of the conservation area. Whether or not those particular facts will enable the case to be steered around, or whether it will become a potential case which developers can use to argue for a much wider assessment of the benefits of the scheme. We shall see, but it certainly is something which will give those concerned with enforcement in local, in listed building cases, at least pause for thought about how the benefit arguments might run. So those are my remaining thoughts. I'll come back to you during the question session, but now we'll switch to Charles for the remaining two cases to talk about in this session. Charles.
Thank you very much, Andrew. Hopefully all of you could see my screen now. Right, well, I've got two more cases to go through, and I'm conscious of the time, so I will be as quick as I can. This is the first case, Crown against Panayi. It's a Court of Appeal case, Males LJ. It was, what this case is about, it relates to a confiscation order under the Proceeds of Crime Act 2002. And many of you will be aware that a confiscation order under POCA, as it's called, POCA 2002, it's designed to strip from guilty defendants the benefit of their offending. And it it comes up in various contexts in criminal law, and one of the contexts in which it arises, I think, particularly commonly is in regulatory, especially planning. So just a quick summary of the facts, because they are very important to this case. The defendant, who was being prosecuted, had obtained planning permission to build a mansard roof extension to his freehold property on the Caledonian Road. However, and he had form for this kind of thing, the extension that he built what materially exceeded the dimensions, so it was bigger than it should have been, and what's more, it was visible from the streets, and it detracted from the character of the conservation area. Accordingly, the council issued an enforcement notice, and this is all back in 2003. The council issued an enforcement notice against that breach of planning control. Now, the defendant took various steps to try and regularise the position. None of them were successful. But what's important for this case is, in the meantime, he had converted this mansard roof extension, he'd converted it into 2 flats and had let them out during this period. He was eventually prosecuted by the council sometime later, a long time later. And importantly for this case, he was charged with reference to only 1 day. So he was said to be guilty of, or he was charged with failure to comply with an enforcement notice on or about the 18th of February 2016. So it's the way it's charged is just 1 day, either on the 18th of February 2016 or around that time. Now, he was convicted in Highbury Corner Magistrates Court, and he was committed to the Crown Court for sentence, where a confiscation order was considered by the court. And Blackfriars Crown Court, for the sentence, they imposed a fine against the defendant of £25,000. And in the confiscation proceedings, the defendant was made subject to a confiscation order in the sum of nearly £100,000, so a large sum of money. And the way the court arrived at that sum is they took half the rental income that the defendant received from letting the 2 flats in the unlawful extension. They took half the rental income from the 28th of May 2017. And obviously what the court's doing there is it was taking into account quite a long period of time, hence why the sum under the confiscation order was so large. The defendant appealed against that sentence and the confiscation order to the Court of Appeal, and the issue which the Court of Appeal had to determine was, can the calculation of the benefit for the purposes of confiscation proceedings, can it extend over any greater period than the period charged? And as I said, the period charged in this case was just 1 day. And this is what the Court of Appeal decided. They allowed the appeal against the confiscation order, and they reduced the sum payable under it by a significant amount. They reduced it from roughly £96,000 down to £58. And the court's reasoning was based just on a reading of the Act in question, the Proceeds of Crime Act 2002. And what the court said is, where the court decides that the defendant doesn't have a criminal lifestyle, so that changes the procedure. But in this case, it was decided that the defendant did not have a criminal lifestyle. In those circumstances, under Section 76, the benefit which the court needs to identify when it's deciding whether to make a confiscation order and how much, what it needs to identify is the benefit obtained as a result of or in connection with the criminal conduct of which the defendant has been convicted or in respect of which he has pleaded guilty. So there's no scope for the court to find that the defendant has committed other or more extensive offences and then go on to identify the benefit which he has received from that further offending. So in this case, as I said, the counsel chose to charge the defendant by reference to a single day. That was the 18th of February in 2016. And the benefit obtained as a result of or in connection with that particular criminal conduct had to be referable to the offence to which the defendant, with which the defendant was charged. And in this case, that meant that the rent obtained by the defendant letting out the flats in question from 2005 or 2007 onwards, that could not be taken into account. That could not be regarded as having been obtained in connection with the criminal conduct. And what counsel for the local planning authority tried to argue is they said, well, you know, what about, we didn't just charge him in relation to the 18th of February 2016, we charged him in relation, we said, well, on or about. So it's not just, you know, one day. And the court gave that argument short shrift. It said, well, that doesn't assist the council, and it wouldn't assist any other prosecuting authority in these circumstances, because you're still prosecuting according to a single day. You don't necessarily know exactly which day that will be. It will be on or about the 18th of February, but it's still, you are prosecuting with reference to a single day. And so, I mean, this is sort of, I think, not the last word that will be had on this in the Court of Appeal. It's many, I think many confiscation orders have been made which are inconsistent with this principle. And the question is, what is its scope? I mean, this case involved rental income from letting out a flat, which is reasonably common in planning prosecutions. But what about when you're trying to realise the increase in value of some unlawful development, etc.? So I think this issue will be revisited, because it's incredibly significant in terms of how prosecuting authorities, how they will charge the offence. I mean, there are often perfectly reasonable reasons why an offence might be charged with reference to only one day, or with reference to a much smaller period than actually the offending took place over. In the meantime, I think what's important to note is obviously that prosecuting authorities, it's set out in section 1796 of the Town and Country Planning Act, that the offence under section 179, or the offences, can be charged by reference to any day or longer period in time, and then says that a person can be convicted of second subsequent offences. But the point is it's within, if prosecuting authorities know that they're likely to want to apply for a confiscation order, obviously it's in their gift to charge the offence accordingly over a longer period, if you want to capture this kind of rental income as was attempted to be captured in this case. And obviously, if you're advising defendants, you need to bear this in mind, because one, in terms of resisting confiscation orders which fall foul of this, of the principle in this case, but also in terms of the terms that you might, if you're negotiating the terms of your client's guilty plea, obviously the charge, how that, the period with which it has been prosecuted, that could be incredibly important to your client. That can make a big difference. So it's important. It's an important case for both prosecuting authorities and also people who will be advising defendants. This last slide relates to the sentence. So I've been talking about the confiscation order, the sentence of 25,000, which the Crown Court imposed. The Court of Appeal did uphold that fine, It was not wrong in principle or manifestly excessive. And interestingly, what the court did in upholding that fine of 25,000 is the court said, well, even though the conviction related to conduct on a single day, the court took into account the fact that it was accepted that the defendant had acted unlawfully for a longer period of time. And that may well be just because they're not limited by the words, by the rather strict interpretation of the words in the Proceeds of Crime Act. So in terms of sentencing, where the court had more discretion, it did take into account the extent in time of the criminality. And there are also other considerations that you'd expect, which I've put there, which also informed upholding that sentence. For example, deliberately offending with a view to financial gain, etc. And as I said, he did have form for this. So that's an interesting case on proceeds of crime. The final case I'm going to talk about quickly is Finnegan and Southampton City Council. This is a case about Section 70C of the Town and Country Planning Act 1990, and many of you will be aware of this power, and it's the power to decline to determine retrospective applications. And it says that a local planning authority may, there's a discretion, decline to determine an application for planning permission for the development of any land if granting planning permission for the development would involve granting planning permission in respect of the whole or any part of the matters specified in the enforcement notice as constituting a breach of planning control. And a pre-existing enforcement notice is defined in subsection 2 as an enforcement notice issued before the application was received by the local planning authority. And this is one of a number of powers that local planning authorities have to essentially just try and stop enforcement. Can become very complicated in terms of applications, retrospective or otherwise, and enforcement, and whether an enforcement is still valid and upheld, etc. So this is one of many powers that local planning authorities have to try and keep a lid on many of these enforcement issues, which can get out of hand. So these are the facts, which I'll go through briefly. The claimant occupied a site, the last lawful use of which had been office use. The council served an enforcement notice on the claimant alleging a breach of planning control by the change of use of the site to a mixed use of storage, display and sale of motor vehicles and residential use. The claimant appealed against that enforcement notice, and part of that was a Ground A appeal. And under that Ground A appeal, the claimant was essentially seeking permission for what was essentially the matters constituting the breach of planning control in the enforcement notice. The appeal was dismissed and the enforcement notice was upheld. Thereafter, the claimant applied to the council for planning permission for a slightly different proposal, and that was changed to a sui generis use for the sale of motor vehicles, limited to the southern part of the site and subject to new conditions which had not been part of his Ground A appeal. So that's the claimant applying to the local planning authority with this new and different proposal. And the council declined to determine that application, relying on section 70C, subsection 1. The council concluded that there had been no material change in circumstances since the enforcement notice had been issued, and therefore it was entitled to rely on section 70C. The claimant sought judicial review of that decision. What the claimant was contending was that it was essentially arguing for a narrower interpretation of section 70C. It was saying, well, section 70C was or is designed to prevent an applicant from having the same proposal considered twice. And he was saying, well, the merits of my current application had not been considered previously, since the proposal considered by the inspector in my enforcement notice appeal, well, that had been something different. So the thing I'm proposing now, which I'm applying for permission for now, it hasn't been considered. It's different from what was considered in the enforcement notice appeal. And perhaps unsurprisingly, the court dismissed this claim, and in so doing, it further emphasised that Section 70C conferred a broad statutory discretion on the council about whether to decline to determine a planning application. And this broad statutory discretion is designed to further the purpose of Section 70C. What is that purpose? It's to ensure, as I was saying in relation to the first slide, the purpose is to ensure that effective enforcement could not be avoided or delayed by those in breach of planning control having multiple bites of the cherry. And the court held that it would be contrary to that purpose to allow an application for a proposal which overlapped with a previously issued enforcement notice to proceed if it would merely and self-evidently create future enforcement issues. And in that regard, the issue was whether the applicant had had an opportunity to canvass the planning merits of a proposal, not simply whether that opportunity had been taken. So what the claimant was saying, the appellant in the Section 289 as judicial research, that what the claimant was saying was that, well, I haven't had this opportunity because this proposal hadn't been considered before. And the court said, well, no, you might not have taken that opportunity, but you did have that opportunity. And accordingly, the council could rely on Section 70C in its broad discretion in order to further the purpose of that section. And just a final point, which is that, as one would expect, the discretion by the local planning authority is the exercise of planning judgment, which will only be impugned by the court if the council had fallen into legal error. So thank you very much, Andrew. Back to you.
Thank you, Charles. Well, I feel the pain of those involved in Finnegan. I got a very bloody nose in the High Court a couple of years ago trying to argue almost a similar point, but it was on a leave application and we never got far enough to get into the law reports. But the Finnegan decision, not surprising, that Section 70C jurisdiction is very wide, very difficult consideration, and various formulations of the argument that it had to be considering something which had the same planning merits have bit the dust on a number of occasions. So interesting again to see it happening. We've got just a handful of questions. The first is an interesting note, and it goes to demonstrate that you never quite know who is being kind enough to tune into these webinars. But I'm told on high authority that Stratford Council have taken the hint from the Supreme Court in the Dill case, and Mr. Dill sleeps easy without his urns, as the notice has been withdrawn by the council. And I think that's probably good to hear. The question of substance, just to touch upon, is from Andrew Cook, who asks about whether or not, given that conditions have to go to the heart of the permission, could they nevertheless fall outside the definition by not including the right formula of words, i.e., if you've got a condition that does go to the heart of the subject matter of the permission, but isn't worded clearly enough as a pre-commencement condition, does it still qualify as a pre-commencement condition? To which my answer would certainly be, I think, no. Both elements of that test are very important. And in a sense, the wording of the condition is really the gateway to even getting to first base, to mix various metaphors. But it's the thing to getting to first base, really, in terms of whether or not it falls as a condition precedent. You'll recall the basic rules for interpretation of conditions in terms of a proper common sense reading as per Trump. And so therefore the wording is pretty fundamental to the initial establishment of the fact that it's a pre-commencement condition. So my answer, I think, would be unequivocally that in a sense you need, insofar as in something which is as fluid as the issue of pre-commencement conditions still is, every case we think has clarified it, and then something else comes along to unclarify it. But insofar as that fluid definition in the broader sense of the word is there, I would say unequivocally, in a sense, you need both limbs of it, i.e. proper wording, and then a proper consideration in all the circumstances of going to the heart of the permission. I don't know whether you would agree with that view, Charles.
I would, and I had a quick look at all the condition precedent cases that I'm aware of, and every single one fell into sort of the formula that you'd expect, and it was sort of taken as read that, well, they meet that sort of formula. The question is, does it go to the heart of the planning permission? So I'm not aware of one that hasn't met that sort of basic gateway, but it would be interesting to see if someone tries to argue otherwise, perhaps by implication or from an interpretation point of view. But no, I agree.
Yeah, and just the final query really we have is from Safina Ahmed, who wonders whether the developers in Melsels had actually agreed with the pre-commencement conditions. I don't know, perhaps you do, Charles, but I would say that even if they had, that's really the way things develop in the course of as I say, many a slip twixt cup and lip, and the way things develop in planning situations, often position one adopts at the outset may be thought to be wrong at a later time. And so I don't know if you do, Charles, but I would say it doesn't in a sense really matter either for the case or to how people subsequently behave.
Yeah, absolutely agree. I did check the case to see if they had agreed. It wouldn't have been under the regulations, obviously, because I think the planning permission was granted in 2006. There was no indication whether they did agree with it or not, but I completely agree. It would be immaterial either way.
Good, thank you very much. Well, thank you, Charles, for your contribution. That's the end of our questions, and I see people are going off to get their pre-lunch cup of tea. So thank you very much all for your attendance. Thank you, Charles, for your contribution. I hope it's been helpful, and we will see you again, I think, next week for the next in the FTB webinar series, which is on infrastructure matters. And I think after that we take a summer break from this webinar series, but all the recordings are available on the FTB website, and the slides of this will be distributed to participants. So thank you very much indeed, everybody. Good morning.
Thank you very much.